Well, hello, everybody, and welcome to the D&O Claim Trends webinar, part two. I'm Marketing Manager Sherry Branson. I'm now joined by the President of Kevin Davis Insurance, Mr. Kevin Davis.
Hey, Sherry.
Hey, Kevin, how are you?
I'm doing pretty good. How you doing today?
I'm doing great, doing great. Thank you for, Kevin has a little bit of a head cold, but thank you for
Yeah.
doing the webinar anyway today, Kevin. You're powering right through, you know.
Yeah. It's really funny because I haven't been sick for a while, and I don't know if it's allergies or sinuses or cold. I haven't figured that out. In the springtime, so it could be all of them. Who knows?
Yeah,
Yeah. Yeah.
yeah, spring
hmm
colds are really common.
hmm
Yeah.
hmm
And thank you for doing the webinar today, Kevin. And thank you everybody for joining us. We have people joining us from all over the country. And I did want to mention one thing. If you'd like a copy of today's presentation, please send me an email to sherry.branson@amwins.com, and I'm happy to send you a copy of today's presentation. We also record all of our webinars. It takes about a day to get the recording. So if you'd like a recording to listen to it again, please send me an email as well, and I'll send you a link to our YouTube recording. Please take a second to read the disclaimer on the screen. And Kevin, we have a great topic today. We're back by popular demand. I mean, we did we did claim trends the last time around, just a couple of months ago, and now we're doing part two. So we have a great topic that was very popular, and people want to learn more about what's going on in the claims world for community associations.
Yeah, you know what? And this is this is one of those trends that we never talk about because they're insignificant. They're minor, but they're creating a huge problem out there, more so than ever before. And we're seeing procedure claims, and they just turn into nightmares for community associations. And so what we're going to do today is talk about what they are and how a comprehensive D&O makes a difference. Because without that comprehensive D&O policy, guess what? These procedural claims would not be covered.
Absolutely. Kevin, so the million-dollar question is, what exactly is a procedural claim? People are
Okay. Yes. These are nuisance claims. These are frivolous claims against the board of directors who they do it for one reason, to bother, harass, humiliate the association because the association failed to abide by the governing documents. Okay. The job of the board of directors is to enforce the rules, collect assessments, maintain association. Number one thing I do is enforce the rules. And when you don't do it, guess what happens? You get sued. And these procedure ones are really, really simple. Like, for example, Sherry, you live in a HOA, right? You live in a homeowner association, right?
I do.
Now, here's the problem, okay? Let's say every Friday you put your trash cans out, okay?
Mm-hmm.
Now, here it is Tuesday, and it's 2 o'clock, it's 1 o'clock in the afternoon where you're at, right? Or 2 o'clock in the afternoon where you're at, right? In
Mm-hmm.
Florida. Now, normally you would be at work and things like that, but because of we all live at home now, you're looking out your window, and what do you see? That trash can still out there from,
Mm-hmm.
last, right?
Right, blowing down the street in the wind. Mm-hmm.
Yeah, exactly. Yeah, you
Mm-hmm.
got wind. Like we have rain. We had a lot of rain out there recently, so those trash cans are all piled up in front of my place all of a sudden. Um, and here's the issue, Sherry. Those trash cans have to be put in by 48 hours
Mm-hmm.
according to the documents, right?
Mm-hmm.
According to your
Mm-hmm.
documents, Sherry, those trash can be in 48 hours. Now you're looking outside your window. The wind blew your neighbor's trash can out there.
Mm-hmm.
He
Mm-hmm.
hasn't been home in about 3 or 4 days because he went out and he went over the weekend and enjoyed himself. And then you look outside there and you see, wait a minute, there's a lot of people not taking their trash cans back. What is
Mm-hmm.
wrong? What's happening out there?
Mm-hmm.
So now you're not going to do this because you got better, more important things to do. But there's always that one person in the association who says, guess what, board of directors? You're the ones incompetent. How dare you? These trash cans been out there for at least 3 or 4 days and you didn't do anything about it.
Right.
So I'm holding you responsible for it because you are not abiding by the rules as outlined in association bylaws.
Mm-hmm. Absolutely. And Kevin, as we've discussed in other webinars, so many people are working from home now that they have more time on their hands. They're seeing the trash cans, they're seeing the violations in the neighborhood, and they're reporting them.
Yeah.
So COVID really changed a lot of things with so many remote workers.
So many remote workers, and again, we're seeing things that we don't like. We go outside and we pickleball, making noises, and all kind of different things that we're seeing. People are smoking, leaving cigarette butts in there. We didn't see that historically, but now 2 o'clock in the afternoon, we're seeing these things, and that was creating a problem.
Absolutely. Yeah, the
Yeah,
noise, you wouldn't think that pickleball would be loud, but it can be loud. We have a
yeah,
league in our neighborhood and a lot of people are at the courts and they're playing all the time and it's a big crowd. So it
yeah,
can be loud. So different things have cropped up, new
yeah.
claims and new areas that we hadn't thought of before where there would be a claim.
Yeah, so what I did was divide those procedural claims in three areas. Okay. Violation of the governing documents, financial, election disputes. These are the things that we looked at and said, these are the issues that we're seeing. And when we talk about violation of the governing documents, again, it's that 48 hours that you got to get those trash cans. And if you don't get them, guess what happens? You may get a violation letter or something, or maybe a fine. But what happens is that one individual who lives in that association thinks the board is incompetent, they're not doing a job. Because the board has one job to do and enforce the documents, and guess what they're not doing? They're not enforcing those documents. So I'm making a claim against them. Or the rules you have, and most of the time, parking and pets is the biggest one. You parked in visitors parking, you shouldn't have parked where you shouldn't have parked at, and you towed my car away without due notice. I
Hmm.
understand you have to tow the car away because I parked in visitors parking, but guess what you did not do? You did not give me the due notice as outlined in the documents.
Hmm.
You know, you
And
did
pets,
you have to
comfort
pet.
pets, comfort pets are a big issue. Emotional
Yes.
support animals, etc., where the bylaws might call for a dog a certain size, or the only pets that you can have are a dog or a cat, and somebody gets something else, an unusual pet.
Mhm.
Pot-belly pigs are popular, I know. I mean, so there's lots of pet violations that we see, Kevin.
Exactly. These are all, and then just arbitrary rule enforcement. Talk about the parking situation. Any situation, all of a sudden you're going after me and not going after the other person who's in violation.
Hmm.
So it's just arbitrary enforcement of violations. But again, these violations these procedural claims are absolute. The document says this is what you must do. The
Hmm.
big one is election disputes. I mean, for some reason, it locks into what we see in the United States. We do see fake elections, rigged elections, and basically improper notice was given,
Hmm.
you know, improper use of proxies. The person's not
Hmm.
qualified to run. This person's not qualified to run because he had maybe paid all his assessments. He may be a renter. It may be some other reason why. But what happens is that again, these people will file a claim against the board. Now, here's the tricky thing about these things is that we're not talking about financial damages here. We're talking about, I happen to be that one person association that's nothing more to do than make sure that everybody's complying with the rules. The pool's closed now? Why is the pool not open right now when it should be open? You're in violation, and the board's not doing anything about this. I'm challenging the board. I'm running for the board myself because I believe I can do a better job than the current board members can do. And what
Hmm.
happens is that now all of a sudden you got these proxies and things going on right now where I'm not permitted because I haven't been given notice properly. You
Hmm.
haven't told me about it.
Hmm.
And the big problem when talking about procedural claims is financial disputes. When I go after you, Sherry, I want more money. I'm raising your assessments by 10%. I mean, we have a special assessment because we need new roofs, right? I'm imposing these fines on you because you didn't move your trash cans. Now, all of a sudden, you're not happy about it. And you're
Hmm.
saying, wait a minute, you're not allowed to impose. Okay, you can't increase those assessments 10% because in the document said the most you can do in any 1 year is 3%.
Hmm.
So now you're in violation.
Hmm.
Yeah.
Absolutely. Yeah. If I mean, the board members, a lot of them don't realize how much responsibility they do have and to know exactly what's in the bylaws and follow it to a T. Because if they don't, there's always somebody who's going to notice or who's going to be on top of it and make sure that they call them out on it and maybe file a claim and, regarding the election and proper notice, et cetera. So they have a big responsibility. It's like a job. It's a real job.
And now here's the problem we have. You take any situation in the court, you're sitting in front of a judge, right? And the judge is hearing this complaint from this individual who lives in association. He has a lawyer, or he may not even have a lawyer. He may be acting on his own behalf, saying
Hmm.
that, listen, I've been living here for the past 15 years and I'm tired of those trash cans not being removed in 48 hours. Or I'm tired of being ridiculed and blamed and challenged because I'm parking the business parking.
Hmm.
The judge is going to say, how were you harmed? What were the damages? And you go,
Right.
no, it's not about damages or harm. I think the board's incompetent, and I want them to know they're incompetent. So I want you, judge, to agree with me and say that these boards are incompetent. And the judge hates these things because guess what happened? I mean, there's no damages, there's no harm being done, but these individuals get into these emotional states and they're sued. Now, here's the problem. Another problem is number one, they act on their own behalf. So they don't have a lawyer. They act on their own. It's like, Sherry, you got mad at those person, the trash can kept winding up in Europe because of the wind. You can represent yourself. You can just go Google how to represent myself in a court of law. You can do it. Or what you can do is hire an attorney and say, listen, I can't make any money off of this thing. You can say, guess what? I'm rich. I got a ton of money. Don't worry about it. Or you can say, we happen to live in an area what's called prevailing party fees. Prevailing party fees means that if I win, I get to collect all the fees from the other person.
Mm.
Okay. So now all of a sudden that attorney is saying, well, you know what? It says in documents you got 48 hours. You didn't get them in 48 hours. I already won. It's over. The case is over.
Right.
So I'm going to sit there and go, well, judge, guess what? He violated the law. He violated documents. He violated documents. And I want to string this thing out. I don't want to settle this thing, immediately. And I'm going to throw different things on there to make this thing go bigger and bigger and bigger. So now we're going to show you how this thing works, Sherry. We're going to pull up an actual claim. And we pull up this claim. I'm going to read this claim to you. And I want you guys, whoever's listening here, to put in the chat. Is this a D&O claim, a GL claim, excess claim, all the above? Okay. Are we ready?
Yes, please answer this claim. Let us know what type of claim you think it is. And Kevin, I just want to mention one thing that quite often we get a lot of questions about, is this a GL? Is this a D&O claim? And a lot of times there's some gray areas, and so we're going to distinguish between the two and help people realize that quite often, it just helps them determine which category it falls into so they're not confused by it. So go ahead.
All right, so here we go. A claim is made against the board president of the association by a former board member alleging he was deprived the opportunity to run for the board by illegal use of proxies. Now, there's a claim for slander, defamation, emotional distress, harassment, unjust enrichment, loss of reputation, as well as an apology from the board president, which can be read at a board meeting. So I want people to make some commitments in the chat. What do you think this is? D&O, GL, or you have no idea?
Okay. If you all could type your answers into the box. Joshua Chaffee says, let's see. Let me see if you could type in here. I'll see if I can. Let's see. He's disabled, Troy. If you could fix his. George Krim says D&O. Aaron Burns says D&O. And Steve Aladdin has a comment, Kevin. He says, hi, Kevin. Problem is there's always one person that feels discriminated upon, whether they're right or wrong. That's true. That's true, Steve. And then, so we have most people saying D&O.
D&O, okay.
Aaron and Andrew. And somebody raised their hand. Let's see what Diana says here. Let's see. What is she? Oh, okay. Not sure.
Okay, so let's do this. Let's go to the definitions. Let's talk about a GL first. What is a GL? And this is why is it a D&O versus a GL? The reality is, guys, we'll tell you what it's going to be. So if you look at what a GL is, okay, we'll talk about a GL, the general liability. A GL pays a sum the insured is legally obligated to pay as damages, but you have to have a suit for damages. The key is a suit for damages. Pays those sums legally obligated to pay as damages and have the right and duty to defend the insured against any suit for these damages.
So there has to be a lawsuit, Kevin. So that
exactly.
A lawsuit.
Exactly.
Okay.
This is the difference here.
Okay.
Now, this is tricky. Okay, it pays those sums that the insured becomes legally obligated to pay as damages. And have the right and duty to defend against any suit for those damages. So it's two things in there.
Okay.
Two pieces in there. obligate to pay us damages, and a right and duty to defend against them. Now, if we go to the next slide, we talk about what D&O is, directors and officers, okay? A D&O policy pays the insured for loss for any claim for a wrongful act made against them and shall have a right and duty to defend any claim. And a claim is a written demand for monetary or non-monetary relief. Okay. Now, let's look at what he's saying here. The D&O is a claim. So we never said it's a suit. If we go back to that claim again, Troy, go back a couple times. There you go. A claim is made. So we're talking about a claim, no suit, against a board member for monetary or non-monetary damages. The claim is against a board of directors, and what they want is an apology letter.
Right. They don't want money. They don't want money.
Yeah.
They just want an apology.
The claim is for an apology letter against the meeting. Now, he also has slander, defamation, emotional distress, all those things locked in there also. So it becomes complicated. And that's the point of these things. It is complicated. As soon as I said a claim is made against the board of directors by a former board member, okay, because he wanted to be on the board and all he wants is a letter. He wants a letter. Now, he says this other stuff too, we're going to talk about, but he wants a letter read to the board because he was hurt. His feelings were hurt.
Right.
Okay.
Quite often, Kevin, the D&O claims that we see, there are just somebody wants an apology. They want to be able to paint their house a certain color. They want to get that emotional support animal. So it's not about money most of the time.
Yeah. So what did we learn here? Now, this is the interesting part. So we had a claim made against the board president by a former board member. Okay. Now, the first thing we're going to talk about is that, wait a minute, how expansive is our D&O policy?
Right.
Will we pick up former board members suing a current board member?
Right.
Because that is what's called an insured versus insured exclusion.
Right.
Okay.
Right.
All right. So do we pick that up or not?
We do.
Another thing is in there. We look at what's called emotional distress claims. Okay. Libel, slander, defamation, emotional distress. Are those things covered under the D&O policy? Well, you got to make sure that the libel, slander, defamation, loss of reputation, those are D&O claims that we're seeing more and more. And that's why when we talk about frivolous claims, all this is for one thing. This person wanted to be on the board of directors because he believed he can benefit, he can be helpful to the board. And the current board said, we don't want him there, or they just didn't want him to be part of, so they didn't give him the proper notification. He didn't see it. So now all of a sudden we have this claim. Now, I said before, these are nuisance claims. These claims can cost a couple $1,000s. Okay. So now let's go to the final here. Let's go to that next slide there. So here's what it is. It was shared by the D&O and the GL. There's $250,000 in defense costs of this thing. The GL picked up the emotional distress and a loss of reputation. Now, for those people who love GL and thinks GL is everything about GL, when you talk about emotional distress may or may not be covered. Because if we talk about bodily injury, there was no bodily injury in here.
Right.
So if you're in the wrong state, emotional stress would not be picked up under any situation for the D&O or the GL.
Interesting. Very interesting.
Okay. So emotional stress, it depends on your state. Because we pick bodily injury and property damage covers the GL. Okay. Emotional stress, if you're suing for emotional stress, it has to accompany bodily injury. Unless your state says, guess what? We think emotional stress is considered bodily injury. So this is a really complicated thing, but we see how much money it costs. Okay.
And most of these claims are very emotionally driven, as you said. So emotional distress usually is part of a situation like this, or other situations where they're upset about the emotional support animal, the painting for the house, etc.
And that's why what happened when you have these kind of claims, you have to be able to, number one, put both carriers on notice. Put your D&O, your GL on notice. Put them both on notice, because what will happen is that the D&O person, even though, again, the claim Okay, the DNO has a duty to defend a claim. A GL has a duty to investigate a claim. They don't have to defend it, they have a duty to investigate. Now, what happens is that there was a demand for damages, and the damages were the loss of reputation and emotional stress. That's why the GL got involved in it.
Mm-hmm.
At the end, we
Interesting.
split it 50-50.
Mm-hmm. So it's much more complex than people realize, I think. It's not always so clear cut, one or the
Yes.
other. There's crossover there.
And this is the problem we're saying in terms of trends. This is not new, but what's new is that, again, it's 2 o'clock in the afternoon, 2:20 in the afternoon. You're looking outside your window and you're seeing things you don't like. And the things you don't like are violations against the board of directors, a violation against an individual there, and the board has chose not to do anything about it.
Right.
So not only they chose not to do anything about it, guess what? I'm upset. I'm emotionally upset because they ignored me. I haven't been heard.
Right.
You know? If I
Right.
haven't been heard, guess what happens now? I'm suing because guess what? People are looking at me at the pool, accusing me of suing the board of directors, and the board is doing their job. And all I want is the board to enforce the rules that's outlined in the governing documents. That's all I want them to do. Okay.
Right.
If they're not doing it, guess what my job is to do? Is to make sure they're doing their job. And why everybody attacking me? So now all of a sudden there's a lost reputation. Yeah, you know, all the things we talked about in that last, there's unlawful and unlawful enrichment. Okay, you know, because all of a sudden they're accusing me of doing things I shouldn't have done, and I received a benefit from it. You know, there's so many different things that happen, and it ends up costing, just in defense, that $250,000 in defense costs.
Yeah, it's very
Then
expensive.
there's a
And
$100,000 judgment, and for something simple. And that's why these kind of claims, this kind of things here become a nuisance for us on the DNO side and the GL side. Okay. And we want to do something about it. So,
and
so
I
what we're
did
going
want
to
to
do now.
mention one more time,
Sure.
if you have any questions, if we have time at the end, Kevin will and I will do a Q&A session if we have time. But if you think of questions later on, feel free to send me an email to sherry.branson@amwins.com, and I'm happy to answer your questions after the webinar.
Okay, so let's talk about how we can avoid these frivolous suits, because the key thing is that, first of all, you have to make sure you have the right DNO policy. Okay, it's so important because, you know, we saw in that one claim, there was a suit, that it was a claim against the board for non-monetary damages. He wanted a letter. If you have a DNO policy out there, it doesn't pick up the non-monetary damages, guess what? You out of luck on that
You're
one
in luck.
situation.
Yeah, you have no coverage. You have no
You have no
coverage.
coverage.
Yeah,
Okay.
non-monetary is extremely important. As we discussed before, Kevin, like you said earlier in the webinar today, wouldn't you say most of the claims are non-monetary in an association?
Yeah.
A good,
Because of these frivolous claims
right.
we're talking about, these are the number one kind of claims we're going to see in association.
Yeah, the
They're not
majority.
asking for money. I believe the board of directors is incompetent and lack the ability to do their job properly. And guess what happens when I say the board's incompetent? Now I'm challenging the board's authority. And now guess what they can do? They can sue me.
Right,
Okay.
slander.
But I
Slander.
crossed the line.
Mm-hmm.
You know, I'm
Yeah,
not allowed to say these certain things because now all of a sudden I harm them. They can sue me for loss of reputation. They can sue
right.
me for slander.
Right, right. We just had a situation in my HOA last year where there was a mistake made in the budget, and so the HOA fees went up dramatically. And you know, there was some line item that was missing in the final budget. So when they set the HOA fees, it was wrong, and then they had to raise it, and everybody was slandering the board members. They were
Yeah.
all complaining
Yeah.
and saying,
Mhm.
do they know what they're doing, and blah blah blah, you know. So yep,
Perfect
right there I
example.
thought, oh boy, I saw it on the
Yep.
Facebook page. I said, this is not going to be good, you know.
And that's another thing that happens here. We talk about social media, creates a bigger problem because you put on social media that, guess what? The
Right,
board was in violation of governing documents because they didn't have the budget in the way they should have properly presented the budget.
right.
And
It was all out there, right there on social media,
Mhm.
complaining, you know, kind of throwing people under the bus, and
Yeah. So let's talk about ways you can avoid these frivolous claims. And board of directors have to understand that times have changed, and so do people who live in these associations. Okay. You have
Mhm.
people who live in the associations that are there most of the day, a lot of
Mhm.
times a day. And there's
Mhm.
certain things they don't like. If they don't like them and they present them to the board has to respond to them and they can't ignore them. Because
Right.
when they ignore them, guess what happens? When you have one trash can situation, okay, where
Mhm.
you're upset by it, and because the board didn't do anything, and guess what you end up doing? You at the pool, right? And all of a sudden you're talking to one of your neighbors, and guess what? I have the same problem. And then all of a sudden you
Right.
talk to another person lives
It
there. Now you
snowballs.
got
It
10.
snowballs. Then we're all
Yeah, you
complaining.
got
They were all complaining at the pool. Yeah.
exactly. And now you got
Mhm.
10 people who are upset against the
Mhm.
board of directors and
Mhm.
say, guess what you're going to do now? I think the board's incompetent because they're not doing the job properly. Now, what
Mhm.
you do is call your attorney up and say, guess what, Mr. Attorney? 10 of
Mhm.
my 10 of my neighbors are upset with the board because they're not doing it. Now, the attorney gonna say, yeah, but there's no damages or anything. Well, I don't understand why you're doing it. The judge, now so you remember, well, wait a minute.
Mhm.
If they lose, then I get to collect all the money for all 10 of these people who live there. So
Right.
I'm gonna take this case.
Right.
It's called
It's good for the
prevailing party
lawyers.
fee.
It's good for the lawyers, Kevin.
Well, again, if you live in a state where you have
Mhm.
those situations where if the person who's doing this suing loses, guess what?
Mhm.
Again, we're going to win because we know you have 48 hours to remove those things. We're going to win. So now you have
Mhm.
10 people there.
Mhm.
And I'm the lawyer in there. I'm on the phone. Okay, so what happened again? How many days it was? I'm sending
Mhm.
photographers out there, taking pictures, I'm
Mhm.
having
Mhm.
specialists
Mhm.
come out there.
How many neighbors are upset?
How
Oh,
many?
50 neighbors? Oh,
And I'll
okay.
send a letter out. Are there more
Mhm.
neighbors outset? Are there more? And now we have what's called a derivative action suit against the association.
Yeah.
Okay.
Yeah, it just
And does that
snowballs.
happen? Yes, it does.
Yes.
It
Yes.
does.
Yes. Yes.
So,
It's big
so
business,
we have to
unfortunately.
understand that the time we live in is different and unique, and you have to understand these things and don't overreact, but you have to treat it as a business.
Mhm.
Okay, it's a business.
It is.
If you
Yeah.
have 100 units and each unit is worth what $100,000, you have
Mhm.
$10 million association that you're running. You're responsible for $10 million. Okay.
Mhm.
All right. And so you got to think about it that I have a $10 million association, I have to run it like business.
Mhm. Mhm.
Right now, everybody's concerned about structural failure, structural engineering, structural issues. Okay.
Yes.
Because of that
Surfside.
building went down,
Surfside.
Surfside building.
Mhm.
Okay.
Mhm.
Have an up to date reserve study and then reserve and then spend the money. Okay.
Yes. Yes.
We hear too often, yes, we did a reserve study, but guess what? We don't have any money. Yes, we did a reserve study and have money, but guess what? We haven't done anything with it. Yes,
Right.
we have a reserve study, have money, but we didn't finish it.
Right.
Come on,
Deferred maintenance, right? We talked about that deferred maintenance where
deferred maintenance.
they raise the fees and then the money sits there and they just kind of kick the can down the road to the next year and the next year. And
Mhm.
unfortunately, that's what happens. That's what
And
happens
what
this time.
happened as you wait, the cost of you repairing that roof gets higher.
Right. Right.
Okay.
It's not going to
So
get
once you have
cheaper.
that
It's not going to
money,
get cheaper.
repair it.
Hmm.
But you don't. You sit on it because you want to have a reserve. Well, guess what? The roof's leaking. You reserve for the roof to take care of the roof. You got to make sure you take care of it.
The balcony's not safe, that kind of a thing.
Yes.
Hmm.
Have an emergency plan. There's a lot
Hmm.
of emergencies happening, especially especially in California. We have the fires.
Yep.
We've seen
Mudslides.
a lot of rain. We've seen a lot of issues that we haven't seen. Okay, we didn't have an earthquake, but New York had an earthquake.
Yeah. Yeah, I know,
a couple of
I
weeks
know.
ago. Yeah,
And it was a pretty
yeah,
big one. It was a 4.8. 4.8. My
yeah.
family felt it in the Northeast. Yeah. Just a crazy.
And so you have an emergency plan in case there's an emergency. Because you don't have one, that's when you come back and have these frivolous claims because you come back and you say, guess what? Nobody told us what to do in these situations. Okay.
Right.
Yeah.
Right. Exactly. With hurricanes in Florida, with storms, with flooding, that kind of a thing, evacuations. Yeah, there definitely has to be an emergency plan. It's their responsibility. Hmm.
And the most important are the last two. Enforce the rules and regulations uniformly. You
Hmm.
got to make sure you treat everybody the same. Don't
Hmm.
go after that one person that's running around the neighborhood and complaining about everything. You got to
Hmm.
do it uniformly because you end up with this big, massive claim that you don't have it. And make sure you have this D&O policy that really matters. We run into situations right now, especially because the market has changed, that we're still running into situations where people are buying an inferior D&O contract. And when the claim comes in, they say, "Will you cover something like this?" I said, "Well, yeah, it's what we see all the time. The claim is because they wanted an apology from the board. Why ask for damages? They just wanted an apology from the board." So those situations we have. So that's the kind of things we want to make sure that the board members understand, managers understand. So it's important so we can lower the temperature and lower some of these claims that we've been seeing.
Absolutely. Absolutely. And now, Kevin, another way that people can mitigate risk a little bit or get advice is travelers' customers can call this risk management helpline, which is a great resource and a great tool to tell your customers about. They would have to have a community association management liability coverage with us. The phone number is on the screen. It's 855-548-8656. It's a great tool. It's free. It's 1 hour free of legal advice regarding, if you think something's a claim, you're concerned it's a claim, or you have questions about anything. It's available Monday through Friday, and you can call from 8 to 5 p.m. Eastern Standard Time. Great resource, great tool, great thing to tell your customers about. And it helps them just have a little bit of peace of mind, because let's face it, board members are not lawyers. They're not, maybe some of them are lawyers, but they're not all lawyers. They're not all lawyers, and they have a big job. Like Kevin says, they have a lot of responsibility. So it's great to have that professional resource and that tool to just pick up the phone and say, "Hey, I've got a question about X, Y, or Z," And great, thank you. And I see looks like we have some questions that have come in, but let's move on. I'm going to mention Kevin's podcast. Kevin and Robert Nordland and Julie Adaman, they host a podcast called Common Sense for Common Areas. It talks about all kinds of trends, current issues facing community associations. It's on Apple, Google, Spotify, and Stitcher, and anywhere you get your podcast. Can you talk about it a little bit? Talk about the podcast, and I know
Oh
you.
yeah, sure. It's a weekly podcast. I do it once a month, and it's a conversation, just like we having right now, Sherry. It's a conversation. It goes a little more detail about this is really designed for boards of directors, and things that can help them to. What we try to do is lower the temperature, because as we lower the temperature, you don't see these kind of claims because they are emotionally based and people constantly reacting to one thing or another. So if you get a chance, please listen to it.
Yeah, if you have board members that you think could benefit from learning from the podcast, they have accountants on they talk about reserve studies, they talk about legal issues, they talk about everything under the sun. Kevin talks about insurance once a month, so feel free to visit his podcast. And now let's see if we have any questions here. Again, if anybody has any questions. Looks like, oh, here we go. Okay. Oh, Steve comments. Steve has a couple comments. GL needs to include mental anguish. Okay. And then let's see. Steve also has a comment. Steve Layden. Problem is many bylaws, proprietary leases are vague and open for litigation. Okay, Kevin.
I'm back.
Oh, okay. I thought I lost you, Kevin.
You know what? When you do these things live, and someone at the door, UPS guy's waving to me. I gotta come. Oh boy!
Oh boy! Okay. There was an emergency or something. Kevin's gone.
It's like, okay,
that happens. Yeah, I've had people ring my doorbell in the middle of a webinar. So
yeah, but I'm sitting right out there, and the guy standing right in front of me. So
he sees you through the glass.
And then this is one of those things that happen when you're home, instead of being. If I'm in my office right now doing
right, it wouldn't be.
It'd be a whole different ball game. But I had to be at home. But anyway, so what was the question? I'm sorry. What was the question?
Oh, that's okay. That's okay. I was just saying Steve Layden had a couple of comments, regarding some issues. But then we do have a question here. Anonymous person typed in a question. If a board receives a complaint or demand and threaten a lawsuit, if the demands aren't met, should that be submitted at that time to both the GL and D&O carriers, or would you suggest waiting till the insured receives a formal lawsuit? Oh, that's a good question. Very good question. Thank you.
Okay. If you a claim is a written demand. So if I send a letter to, if I receive a letter that said, I demand that you stop, whatever it is, submit it then. If you wait until the lawsuit, you have a problem. You're not complying with the terms and conditions of the policy. The terms and conditions of the policy said report a claim. You have to report that claim. If you don't report and you wait, all of a sudden you have something called late reporting of a claim. So you have to do it.
You have to do it. Okay.
Mhm.
Okay.
Mhm.
Thank you for that. And actually, Aaron does have a question. Aaron typed in a couple of questions. Insured versus insured. I think she wants us to explain what insured versus, oh, here she is. Do all D&O policies exclude insured versus insured? Does this apply to board members only? Good question, Aaron. Thank you
Yeah,
for that.
okay. Insured versus insured is standard in most D&O policies because you can't sue yourself. You know, and if I'm currently a board member and Sherry's a board member and Sherry made a decision not to fund the reserves anymore, because she believed that she's going to be moving another year or so. She doesn't want to spend any money. And I get into a battle with her and say, I'm going to challenge you because you don't have the authority to do it. We have to operate, and you're operating in your self-interest. Now, all of a sudden, we're suing each other. Well, that's covered under some policies, and some policies do not cover it. Make sure your D&O policy responds to when one insured sues another insured. Now, the question is who's insured? We have your current board members. If I'm the president, Sherry's the vice president, or past board members. I'm the current president, and Sherry served 5 years ago and doesn't like the job that I'm doing as a board president. So yeah, make sure the past president, or she could be a committee. She can be in charge of the pool hour committee and say, I'm shutting the pool down from now on because of COVID, or COVID-like symptoms or something like that. Okay. And I go in there and says, no, you don't have the authority to do it. So insured is really important coverage and automatically excluded in most policies because you don't want to start covering yourselves, you suing yourselves. Again, if you're like living in your home and you and your wife, you and your spouse get into a fight and you want to sue each other, you can't pick that up. So it's the same situation living in a community association.
Absolutely. It's very important coverage, as Kevin says, with all the board members and past board members, current board members, etc. Great. Looks like, okay, let's see. That looks like it for the questions. Okay, thank you so much for your questions, everybody. And thank you, Kevin, for a great webinar. Thank you for doing it with your cold. I know you're under the weather. Thank you so much. Great webinar, great information. If anybody has any additional questions, I'll give my email one more time. It's sherry.branson@amwins.com. Feel free to email me your questions later on. And if you'd like a copy of today's presentation, I can also send you that. Thanks for joining us, and thank you, Kevin, and have a great afternoon.
All right. Thanks a lot, everybody. Take care.
Bye, everybody. Take care. Have a great day.